Welcome to the second session of our permanent seminar on human rights and global economic governance. Today, we will discuss the future of corporate social responsibility in Latin America. Corporate social responsibility is a multidimensional concept, which, in general terms, means that companies must assume responsibility for the impact of their activities on employees, clients, local communities, and the environment. It is based on an expectation that businesses should avoid the adverse effects of their operations on human rights and the environment, while contributing to the sustainable development of societies in the states where they are operating. Corporate social responsibility principles and standards were first recognized in a series of international soft law instruments, such as the UN Guiding Principles on Business and Human Rights, the ILO Tripartite Declaration of Principles Concerning Multinational Enterprises and Social Policy, and the OECD guidelines for multinational enterprises. Progressively, a shared view appeared at the global level on the need to reform the legal regime of duties and liabilities of companies in the field of corporate social responsibility. Although this concept originated in industrialized economies, some of the major legal innovations in relation to its achievements are implemented in emerging economies because of the growing awareness of its potential to contribute to the resolution of many socio-economic problems faced by developing countries, such as poverty, environmental degradation, human rights and labor abuses, etc. Some of these innovations are taking place in emerging economies across the Latin American region. In this sense, today I have invited my colleague and friend, Professor Ivette Esis, a great expert in international economic law and international law in general from the Finis Terrae University of Chile, to explain to us some of the main innovations in the corporate social responsibility regime in Chile. After that, I will share some aspects about the challenges of the promotion of corporate social responsibility in Mexico. So, Professor Esis, please, the floor is yours.
Thank you so much, Virdzhiniya. Good morning to everyone. Thank you again for your kindly invitation and for the opportunity to share with you and the public about ideas, initiatives of corporate social responsibility in Latin America and especially in Chile. As you said, corporate social responsibility corresponds to a plan organized by the shareholders in order to act and to manage the company operations toward its stakeholders, which are employees, suppliers, shareholders, other ones, and communities. And this plan is not created only or so for philanthropy's objective. Instead, the shareholders acknowledge the importance of the relationship between their company and all their group of interest. And they are very worried to minimize the negative externalities that the operation could generate to these groups. So in Latin America, and especially I will talk about Chile, it has been organized by individual efforts, and Chile is not the exception. So corporate social responsibility in this country date back to 1920, and it was concentrated in individual efforts in order to improve the condition and qualities of the employees' conditions. So nowadays, this matter it's becoming increasingly important to companies, not only for individuals. So the Chile main economic sectors are mining, energy, banking, and finance, agriculture, and in agriculture sector, I will mention fishing, farming, and winemaking. And there is an increasing worry of companies to have corporate social responsibility plans in their corporative governance. And it's also relevant that Chilean universities have been showing interest in corporate social responsibility programs. And there is, I will mention in a few minutes, I will mention about the studies and the initiative organized by Chilean universities about this matter. There is in Chile there is no specific law about corporate social responsibility. In 2013, it was created a special council called Council for Social Responsibility for Sustainable Development, which is part of the Ministry of Economy. Nowadays, we don't have any new information about the council and their activities, but when it was created, the special law, which was enacted in 2013, explained that the council has the function to advise on the development of public policies relating to social responsibility for sustainable development in Chile, and to identify the best practice, national and international, about social responsibility and the initiatives that could be organized in the country. But if we can confirm that the existence of special regulation about the corporate social responsibility in this country. So the first one, I will explain the three main sectors with a special regulation. The first one is the labor sector. So it was enacted in a special law in 2021 about the inclusion of people with disabilities in the labor market, Chilean labor market. In total, 2% of the employees in a company must be people with some disabilities. So in the second sector, which is environmental issues, there are two relevant laws. The first one is the law for waste management, and the regulation aims to generate mechanisms to increase the recycling levels of waste that is currently disposed in landfills or disposed in illegal dumps. And the second law, special law in environmental sector, is the law which was enacted in 2019 about the delivery of plastic bags. So since 2020, in Chile, is prohibited the delivery of this kind of bags. So the failure to comply with this regulation would result for companies in applying up to $2,000 for each bag delivered. The third sector, the important sector, is the finance and banking. there is a special institution, public institution in Chile, which is named Financial Market Commission. This commission has a relevant function in Chile because this commission supervises all the activities for banks and financial institutions, and I mean all security users, stock corporations, banks, and insurance companies. So this Financial Market Commission enacted in 2021 a special, and it's called an administrative law or administrative act called General Rule 461. And these rules require to all the companies which are supervised by the Commission to indicate in their annual reports whether if they are adhere to the UN guiding principles of business and human rights and or other relevant standards or guidelines. And it's really, really important because the Commission wants to know if all these companies integrate the human rights issues into their governance and risk management framework. And it's also very useful for investors and for public, because the investor and the public can evaluate and select financial products according to interests and according to the corporate social responsibility conduct of the company supervised by the Commission. So it's relevant to note that in 2024, last year, it was published a study called Screening ESG NCG 461. And this study analyzed 28 companies for 9 industrial sectors of interest in Chile and showed that the level of quality is more or less 58% in compliance with the special rule 461. And it's very interesting because the study also shows that despite all the progress made by the Chilean companies analyzed, it is still necessary to improve their efficiency in relation to the international best practice on corporate social responsibility. In the international area, Chile has an important role. The country is one of the Latin American state who celebrated a lot of bilateral investment treaties and free trade agreements with many countries in the world. And it's very important to know that Chile has been included in its recent treaties corporate social responsibility clauses. So I will explain the 5 last treaties about it. The first one is the additional protocol of the Pacific Alliance, which was negotiated and celebrated in 2016. In this additional protocol, especially in Chapter 10, recognize the importance of the corporate social responsibility, and the norm, which is the Article 10.30 on the Chapter 10 about investment, established the compromise of each state party to encourage investor to voluntarily incorporate into their corporate governance, corporate responsibility, social standards. The norm also established that the duty of the state parties to identify and to share the best practice in these matters, considering the OCDE guidelines for multinational enterprise. The second treaty was celebrated in 2019. It was the free trade agreement between Argentina and Chile. And the chapter 8 about investment, and particularly the article 817, has a very similar text to the additional protocol, and established that each party, I mean Chile or Argentina, recognize its compromise to comply with the corporate responsibility, social responsibility best practices, including the international guidelines, and to encourage the investor to incorporate them into their politics, internal politics. The third treaty is it is called Comprehensive and Progressive Agreement for Trans-Pacific Partnership. It was celebrated in 2023. It was in the chapter 9 explain the encourage of the state parties to investor to adopt on a voluntary basis again the policies and guidelines about corporate social responsibility. The fourth treaty was celebrated. It was celebrated in 2018, but in 2022 is Biden for this free trade agreement is Biden to Brazil and Chile, and this treaty is very interesting because the treaty has a distinct element: the duty of the investor to develop the social responsibility policies that improve the social economic development of the host state. So it is different from the other three treaties that I mentioned. Why? Because the treaty establishes the foreign investor obligation or duty to comply with the national and international framework in human rights, to promote the human capital formations, to comply with the regulation laws about environmental, health, labor, transaction, financial issues, among others. And the fifth treaty is the Advanced Framework Agreement between Chile and the European Union, which was celebrated in 2022. It has two special chapters. The chapter 17 called investment, and this chapter 13, which has a special regulation on social responsibility, corporate social responsibility for commercial operations. So the first chapter has a special regulation for investment, and the other one special regulation for commerce operations. So for the first one, the treaty has the same solutions in the sense that it established programmatic rules which state parties commit themselves to encourage investors to incorporate this kind of plans into their business. And the chapter 33, which is for commercial operations, recognize the importance of responsible management on supply chains through the social responsibility practice and the role of the trade in achieving this objective. So it is important also to note that Chile is a state member of OCDE, and therefore Chile has the duty to comply with the OCDE guidelines for multinational enterprise on responsible business conduct. And the Subsecretariat of International Economic Relations has a national contact point, and this national contact point has the function, the main function to organize and administrate voluntary and non-voluntary non-contention mechanisms, and the main objective of these mechanisms is to contribute to the resolution of dispute raised when a company had not complied with this guideline. So there are, for at least 20 cases published in the web page of the national contact point of this subsecretariat, that you can see the position of the parties in disputes and the resolution of this national contact point. So there is another point of my presentation very important to share with us, and it's about the emergency initiative and challenge in Chile about corporate social responsibility. And in the Santiago Chamber of Commerce, in a very interesting self-regulatory initiative, published in 2021, the principle of business conduct is like a guideline to all the chamber's participants called socios to contribute to the national sustainable development. And it has 7 principles. One of them is the corporate social responsibility, and the necessity and the duty, or the recommendation to have this kind of plans in their corporate governance. In June 2023, it was we knew about the preparation of a draft act on human rights and business due diligence. But right now we don't have official news about the status of this preliminary draft. We don't know nothing about it. But in 2 years ago, when it was announced, it was published that the draft could be divided in 4 titles: general provisions, the state duty to protect business rights, the responsibility of business enterprise to respect the human rights, and the mechanisms to access to justice and remedies. And and also the law. This draft has a special section on corporate human rights due diligence and sanctions for non-compliance. There is an important university here in Chile called Pontifical Catholic University of Chile, and they have the Faculty of Law of this university has a special program on corporate sustainability. This program each year publishes a special study about corporate social responsibility in Chile. In January 2025, it was like six months ago, this study was published in collaboration with a special group of International Labour Organization and European Union. This latest report includes 28 of 40 private companies listed on the Santiago Stock Exchange, and include public companies, so private and public companies. And it was really interesting because the diagnosis reveals that the percentage of compliance with the principles varies on each economic sector. The electricity companies and generators is the sector which complies in 68% with the social corporate responsibility principles. Retail, 51%, mining, 48%, banking, 31%, transportation, the industry about transportation, 32%, and the result on public company compliance show an improved result, compared to 2023 diagnosis. But there are still opportunities to advance. In this public sector, the National Cooper Corporation has 65% of compliance. The Metro 63%, and the other ones it's around about 44 and 14% with compliance on social corporate responsibility and principles. So in order to conclude my presentation, I want to know that the corporate social responsibility concept is not new in Chile. Although there is no one special law in the matter, it is important to note the auto-regulation effort from companies, and for companies from the Chamber of Commerce and for universities in their work about the contributions of to improve and to encourage to investors, local and foreign investors, to have social responsibility plans into their governance. And the special rule 461 for the enacted by the Financial Market Commission, it has been a very important norms, and although it only applies to entities supervised by the Financial Market Commission, it permits the public to know the level of compliance of the international principles of business and human rights, and especially with the corporate social responsibility principles and best practices. In the international level, the recent incorporation of corporate social responsibility clauses in investment treaties also demonstrate the Chilean state to interest in these subject matters. And the result of all the special reports mentions reveals that Chile has made an important progress in these subject matters, but there is still many opportunities to improve in this sector. Thank you so much, Virginia.
Oh, thank you, Yvette, and well, thank you for sharing with us your thoughtful insight about the achievements, the improvements, but also the future challenges of the promotion of corporate social responsibility in Chile. And I think in all Latin America, we are almost with the same challenges. Things have been advancing, but they're advancing, their improvement is little by little, and we need to make more efforts and adopt more strong public policies for corporate social responsibility. Well, it's the same, or the situation is similar in Mexico. Mexico is currently undergoing a time of big changes in its investment policy due to the so-called fourth political transformation of the state. The new investment policy is mainly favorable to the promotion of corporate social responsibility. Some of Mexico's investment agreements, the same as Chileans, include corporate social responsibility related provisions, but they only establish indirect or soft law duties to companies and don't include specific enforcement or monitoring mechanisms, which, legally speaking, is a big obstacle for the efficient promotion of corporate social responsibility. Regarding Mexican domestic law, corporate social responsibility is recognized only in soft law domestic instruments. Mexico has not adopted a general law on corporate social responsibility. However, as in the Chilean case, there are some important domestic laws which address its labor and environmental dimensions. So there is an urgent need to improve the legal enforcement as well as the normative content of corporate social responsibility provisions in Mexico's domestic laws and regulations and in its international agreements. I will make some remarks and some proposals on this specific point. Regarding Mexico's international investment agreements, Chile and Mexico are one of the champions in Latin America on the ratification of bilateral investment agreements. Mexico has 30 bilateral investment agreements in force with 31 countries or administrative regions. The problem is that most of them are old investment treaties or investment treaties of past generations because they were signed before 2014 when the global discussions about corporate social responsibility began. So only 2 of Mexico's 30 BITs have a corporate social responsibility clause. The first one is the BIT Mexico-Brazil. You were analyzing the BIT Mexico-Chile, and it is the same model, exactly the same. So the interesting thing, as you were saying, in the BITs signed by Brazil is that they try to impose direct duties on investors to make their best efforts to comply with voluntary standards for responsible business conduct. However, the legal language of the CRS clause in Brazil's BIT is very unclear because it begins saying that investors shall try to achieve, which is normally a soft law language, but then it speaks about compliance. It might be interpreted in different ways to say that it imposes direct duties on companies, but the standard of compliance with these duties is not very high. The second bilateral investment treaty signed by Mexico, and which includes a corporate social responsibility clause, is the BIT Mexico-Hong Kong, which was signed in 2020. Of course, everyone who knows the problem with Hong Kong statehood will worry about Mexico signing treaties with what China considers to be one of its administrative regions. But however, there is a corporate social responsibility clause, and it is an indirect clause because it obliges only contracting party, only Mexico and Hong Kong, to encourage their companies to voluntarily incorporate into their internal policy corporate social responsibility guidelines and principles. Regarding Mexico's free trade agreements, which have investment chapters, Mexico has ratified 14 free trade agreements, but only 3 of them, which is a very low percentage, only 3 of Mexico's free trade agreements contain CSR-related provisions. 2 of Mexico's free trade agreement with CSR provisions are also ratified by Chile. So you already explained the CSR clause in the CPTPP and in the additional protocol of the framework agreement of the Pacific Alliance. Both Mexico and Chile have a Pacific coast. That's why they pertain to the Pacific Alliance. The only other Mexican free trade agreement with CSR clauses is the USMCA, the US-Mexico-Canada agreement. But the USMCA has 2 CSR clauses, one in its chapter on investment and the other one in its environmental chapter. Both of them are indirect CSR clauses, the same as in the case of the BIT with Hong Kong. They only establish a duty on states to encourage companies operating in their territory or subject to their jurisdiction to voluntarily incorporate corporate social responsibility standards and principles. So in conclusion, we have very few CSR clauses in Mexico's international agreements. Most of them has hortatory or advisory language, and they all are indirect clauses, except the case with of the BIT with Brazil. But as we were saying, it is unsure either the obligations can be enforced or not. So what do we have regarding the CSR regime in Mexican domestic law? Well, we have a constitutional article 25, which is an indirect recognition of corporate social responsibility, because it states that national economic development will be attended with social responsibility, that's the exact wording of the article, by the private sector. And under criteria of social equity and sustainability, companies will be subject to the modalities dictated by the public interest and the use for general benefit of the productive resources of the Mexican state. So it is a very clear recognition of corporate social responsibility in the Constitution, but it is kind of programmatic constitutional norm which must be incorporated into a law, a general law on corporate social responsibility to become effective, and this has not been done by the Mexican Congress or not still. We have some other soft law domestic instruments. We have what is called a NOM, Norma Oficial Mexicana, or an official Mexican standard on corporate social responsibility. We have some provisions in the Federal Law of Labor, which focuses on socially responsible practices by companies and on avoiding practices that directly affect their employees in aspects such as employee well-being, professional and personal career development, etc. We have some environmental domestic laws which establish direct duties on companies. For example, the Federal Law of Environmental Liability, which establishes that any company who damages the environment must repair or compensate for the damage. We also have the General Law on Climate Change, which obliges companies to report their CO2 emissions to the Ministry of Environment. The General Law for the Prevention and Comprehensive Management of Waste. It can be compared to what you were saying about plastic bags, because it establishes that companies who generate or manage hazardous waste must also notify to the Ministry of Environment what actions they are taking to prevent environmental damages occurred during their economic activities. We have a special distinction of the Mexican Center for Philanthropy. The distinction is granted only to supposedly socially responsible companies, but the Mexican Center for Philanthropy is a non-governmental organization which has its own politics and its own guidelines for giving this distinction. We have a general recommendation of the National Human Rights Commission on the respect and observance of the human rights in companies' activities, but the recommendations of this body are not binding for companies. There are also soft law duties. So I think that the best way to guarantee a better legal enforcement of the company's duties in the area of corporate social responsibility in Mexico will be to incorporate direct CSR clauses in Mexico's investment agreements. There are already some global initiatives, some new investment agreements that go in this direction. Most of them are African investment agreements, and Africa is maybe the other region which has been very active on the promotion of corporate social responsibility for historical reasons, of course. But we have a new Article 22 of the, no, sorry, this is not a new one, but Article 22 of the draft Pan-African Investment Code contained a direct CSR clause, a clause which establishes direct duties on companies to respect corporate social responsibility principles regarding labor, environment, anti-corruption, etc. And the latest African Investment Treaty is the AFCFTA Protocol on Investment. It has an entire chapter called Investor Obligations, which establishes direct duties on companies operating within the territory of one of the member states of this free trade area, of this African free trade area, to respect corporate social responsibility. So I think that Latin America in general and Mexico in particular could follow the African example and adopt new, bolder CSR direct clauses. Now, what can we do with the indirect clauses already contained in Mexico's investment agreements? Can we establish some enforcement proceedings to control that companies, but especially states, are complying with their obligation to encourage companies to respect corporate social responsibility? I think that we can establish at least some kind of monitoring or enforcing mechanisms, such as consultation between state parties to the agreement, administrative supervision. Maybe under the USMCA, we can create an administrative agency with representatives from the 3 member states to monitor Mexico, Canada, and US compliance with the indirect corporate social responsibility clause of the treaty, or with the 2 corporate social responsibility of USMCA. With possible consultation or some kind of supervision, the enforcement mechanisms can improve significantly. Regarding dispute settlements under the investment chapters of Mexico's international agreements, there is a strong discussion in the doctrine of international economic law on the possibility to submit claims based on corporate social responsibility in an investor-state arbitration. However, in an investor-state arbitration, states are always the defendants. So it has been suggested that corporate social responsibility can only be invoked in an investment arbitration proceeding as counterclaims. But maybe in the future we can see more corporate social responsibility clauses invoked in investment arbitration proceedings. In the USMCA, we also have a novelty, which is the facility-specific rapid response labor mechanism. It permits to Mexico or the United States to submit a request for review to the other country to determine if there is a denial of labor right in a specific facility, in a fabric, in a company. So this labor mechanism can be expanded to include not only the labor aspects of corporate social responsibility, but also its environmental aspects, for example. And this can be a very useful enforcement mechanism regarding specifically the USMCA. The legal enforcement of corporate social responsibility in Mexico's domestic law will be significantly improved if Mexico decides to adopt a general law on corporate social responsibility. Once again, there are many countries in Africa, but not only in Africa, that have adopted general regulations on corporate social responsibility. We can mention South Africa's Black Economic Empowerment Initiative, Nigeria's Companies and Allied Matters Act, and some other specific domestic laws on due diligence, on corporate due diligence, of course, such as France due diligence law and Netherlands domestic law on child labor, and the latest initiative of the European Union, which is the European Union Directive on corporate due diligence. Mexico's general law on corporate social responsibility must not only include direct duties for companies, but also effective judicial, administrative, legislative, or other appropriate mechanisms to ensure effective remedies and due process of law regarding compliance by companies with their duties regarding corporate social responsibility. So in conclusion, I might sound like Luigi Ferraioli, but we must always think not only about duties and rights, but also about the guarantees and the enforcement of these duties and rights. Regarding corporate social responsibility, in Latin America and in Mexico, we are only at the first stage. We are only thinking about how to rule about duties, if companies must have direct duties regarding corporate social responsibility, but we must also include in the analysis the second part, which is always the enforcement, or the best way to legally enforce these duties. In conclusion, Ivette, we might say that companies do not have to be charitable entities, as they are established to make profits for their shareholders. However, the globalization period of the international economy and the neoliberal period of the Mexican economy has shown that a socially irresponsible company can be very dangerous for society and commit human rights and environmental abuses. Therefore, as we learned today with your exposition, it is important to improve the legal regime of corporate social responsibility in Chile, in Mexico, in Latin America in general, because companies are not only responsible for their shareholders, they're also responsible for their stakeholders, and we all are stakeholders of the companies. Ivette, I don't know if you want to add something, a final thought, or we can.
Well, I don't have any comment. I am very. I think we have a very similar view about this subject matter, and for me, it was very relevant. That you mentioned that corporate social responsibility conflicts can be or not can be resolved by investment arbitration. And it's a very important questions that could be resolved or answered by the doctrine and the international arbitration in the future. Because as you said, we've seen that in counterclaims, but what will be the next arbitral awards in this matter, we don't know right now. But I agree with you that it will be a very important issue for arbitrations in the very next future. So, and I think it is really important to note it. And I agree with you with the direct and indirect clauses on corporate social responsibility. It is true, especially in investment treaties. And I when I was listening your presentation, I was thinking on the individual efforts from companies in order to have these kind of plans without any legal duty. So because they understood the importance of social responsibility plans in their governance, internal governance. So and I was thinking about the efficiency of this indirect clause, and not only in international investment agreement, and also the efficiency of, of this kind of rules in our internal law or national laws in Latin America. So I think we have a lot of questions, and I think that this question will be answered in the very next future. Thank you, Virginia.
Yes, I fully agree with you. We need to do more research. You were saying about initiatives in Chilean universities.
Yeah.
I think there is, we have a lot to do from the academy, from the Latin American Academy of International Law to discuss more these issues, and that's what we are doing. And I think that's all, and that's enough for our second session. We are inviting everyone to follow the activities of our seminar on the social media of the law department of the Iberoamericana University and Mexico City. We thank everyone for their attention, and please have a nice day.